In previous videos, we've been looking at cases on consideration against the background of a case we're going to look at in a little bit more depth, the case of Rock Advertising against MWB Exchange Centres Limited in the Supreme Court. We will look first at the facts of the case. In a later video, we'll deal with the Court of Appeal's approach to whether or not there was consideration, and then all of those cases we've looked at are going to become important. So the facts of the case are that Rock Advertising had entered into a license agreement for some office space from MWB. Shortly after taking up the license, they got into financial difficulties, and the director of Rock Advertising approached a credit controller of MWB, and they made a verbal agreement to vary or change the terms of the license agreement. Sounds all well and good, but unfortunately in the contract there was a term quite often found in contracts like this that stated that any variation or changes to the contract had to be done in writing and signed by the parties. So the question then was whether or not, when MWB locked out Rock Advertising, whether they had a right to do that. And they would if the non-oral variation clause was effective, but they wouldn't have had a right to do that if that variation that had been made was actually effective. Now, in the county court, they decided that there was an agreement, but that it was ineffective in that it didn't comply with the requirement of the contract to have that variation in writing. Rock Advertising appealed, and it's in the case in the Court of Appeal. The Court of Appeal then reverses the decision of the county court and holds that in fact that oral variation clause was in itself an agreement not only to vary, but to do away with the requirement that all variations had to be in writing. And once they'd come to that conclusion, they then had to look at the issue of consideration. Had Rock Advertising somehow provided consideration to MWB so that they would enforce the promise of MWB's new variation in the contract, which provided that that lease payment could be rescheduled at a smaller amount and over a period of time increasing in a monthly amount, so that by the end of the lease agreement all would be in order and all arrears cleared. So in the next video then we'll look at the issue that the Court of Appeal dealt with as to how they decided there had been consideration to enforce the oral variation of the contract.